us to have a better understanding of how this could help us in evaluating, given that the industry has various aspects to it. So we will evaluate it from a radio station's perspective, and the other case study kind of will do is we will evaluate the act from a producer's point of view. So to begin with, from a radio station's perspective, IPRS could have possibly raised his claim vis-a-vis a radio station primarily on two grounds. One is that when a radio station is exploiting music, is playing music on its platform, it's exploiting sound recording. And by exploiting sound recording, it is in turn communicating the underlying works, is what IPRS is claiming. And the second basis, or the other ground on which it's laying its claim, is Section 18 and Section 19 of the Act, which we dealt with yesterday extensively during our discussion as to what the Act says and the various nuances involved in these two sections, primarily being assignment of copyright and the modes of assignment. Now, if we look into the Act and try to evaluate what is it that a defense that a radio station could possibly take to a claim that IPRS is raising today, to say or to at least put forth a defense that I am not supposed to take a license or an additional license, if I may say so, from IPRS. And to put it very briefly in a pointer form, I would say the defense could be threefold. One is reliance on the judgments right from 1977, which we will deep dive into a little later, to the recent Aditya Pandey judgment, which got delivered by the Supreme Court in 2016. The second defense, to my mind, could be that sound recording is a different class altogether. And the basis for that would be if you go back to our discussion yesterday, where we looked at the definition of work, read with Section 13 and Section 14, where sound recording has definitely been identified as a separate category and a separate class by itself, including where Section 14 specifically provides the rights with a sound recording class has. And the third possible defense will be to evaluate and to go back and see when the 2012 amendments were being made, what was the intent the legislature had while making those amendments. Did it actually wanted sound recording to be read with as a part of literary and musical work, or treat it as a separate class altogether? And I think once we go through and look deeply into all three grounds, we will be, I think that's what a radio station would possibly be telling the court, that given these three reasons, being a platform, I am not supposed to pay license or royalty to IPRS. So continuing, the first leg that I mentioned is the judgment. As briefly mentioned yesterday, IPRS was initially registered sometimes in 1969. I may be wrong a year here and there, but approximately that was the time period when it got registered. And the facts of this case, it's almost so relevant to the issues that today we are facing. That's why I'll just briefly tell you what the facts of this case was. So IPRS was incorporated and was carrying on the business of granting licenses for performance in public of all the existing and future Indian musical work. IPRS, while carrying on this business, issued a tariff which consisted of the fees, charges, and the royalty that will be applicable. Back then, the Producers Association, who were not happy with this whole tariff process and the tariff, approached the court, claiming that they are the owners of the film including the sound recording, and basis that repudiated IPRS's claim, saying and relying on the concept of first owner of copyright, and basing their claim on saying that that no copyright actually subsisted in a composer. Now, this is so similar to the issue that today we are dealing, or the contention that we just read out with regards to what are the possible stands that an IPRS can really take. To this, I'll just read out I'll not read out the whole paragraph, but I'll just draw your attention to what the court back then in 1977 held. So it relied upon section 17, particularly the provisos B and C to section 17.
Sapna,
yes.
before you go there, just one moment. Just for a moment, stop sharing your screen. I want to show everyone what was the issue identified by the Supreme Court to answer.
Sure.
Okay. So just one moment, I will take that and then you can head back to your
okay.
Can everyone see my screen now?
Yeah.
Yes.
All right, I've highlighted a paragraph. This is the first paragraph of that judgment. This appeal by certificate granted under 133(1) of the Constitution by the High Court of Judicature at Calcutta, which is directed against a judgment dated February 13, 1974, raises the following substantial question of law of general importance. Whether in view of the provisions of the Copyright Act 1957, an existing and future rights of music composer / lyricist is capable of assignment, and whether the producer of a cinematograph film can defeat the same by engaging the same person. So very squarely, question that was asked then is the same question to my mind which is relevant even today, is by virtue of the engagement of the people who are authors and who are rendering a service for the purposes of making of the film, can the producer defeat the rights of such people to an existing or a future work by engaging them, and therefore it no longer is capable of assignment? Okay. Sapna, again, because I saw paragraph 17 marked on your presentation, before we go there, that's the final conclusive ratio, but before we go there, it's important
15.
to point out para 15. Do you have that in your presentation?
No, I don't.
I'll
Sure.
focus, I'll just highlight 15. Starts from here where I'm marking the interpretation. Can everyone see that? The interpretation clause F of clause of section 2 reproduced above, which is not exhaustive, leaves no room for doubt when read in conjunction with section 14(1)(c)(3) that the term cinematograph film includes a soundtrack associated with the film. Now, this is a very important conclusion for the court to reach, to finally say what it said. And that's what's relevant even today, when, if you remember right in the beginning of the presentation yesterday, when Sapna was saying that in 13(1), there are 3 categories broadly: the original works, literary, dramatic, musical, artistic. Then there is cinematograph film, and there is sound recording. And there are rights that are distinctly provided for a sound recording under 14E of the Act. 14D deals with cinematograph film, 14E deals with sound recording. 2 separate distinct works. But the definition of a cinematograph film, even today, contains the words includes a sound recording, unlike soundtrack at that point in time. So, for the purposes of determination of what is owned by the film producer, that sound recording becomes relevant, because I told you it has a much more expansive interpretation and leeway compared to a pure sound recording which exists outside of the film. So they say that the term cinematograph film includes a soundtrack associated with the film. In light of the provisions, sorry, I'm just admitting something. In light of the provisions, these provisions, it cannot be disputed that a cinematograph film is to be taken to include the sounds embodied in a soundtrack which is associated with the film. Section 13 recognizes cinematograph film as a distinct and separate class of work and declares that copyright shall subsist therein throughout India. Section 14, which enumerates the rights, it should be rights, that subsist in various classes of works mentioned in Section 13, provides that copyright in case of a literary or musical work means inter alia the right to perform or cause the performance of the work in public, and to make or authorize the making of a cinematograph film or record in respect of the work. Earlier the word was record, not sound recording. That subsequently got amended in 94, but it was just to replace the word record with sound recording. It also provides that copyright in case of a cinematograph film means, among other rights, the rights to exhibiting or causing the exhibition in public of the cinematograph film, that is, of causing the film insofar as it consists of visual images to be seen in public, and insofar as it consists of sounds to be heard in public. Section 13.4, and we'll bring you back to that because that's a very important provision, and to my mind it ties in with the new proviso that has been inserted to Section 17. So very quickly, before we see this argument, I'm just taking you to Section 13.4. It says, the copyright in a film or a sound recording shall not affect the separate copyright in any work in respect of which or a substantial part of which the film, or as the case may be, the sound recording is made. So it recognizes the independent existence of the underlying works, this provision. And the argument that was raised by the Council for IPRS was, look, 13.4 is so categorical that it recognizes the independent existence of the underlying works which go on to make these two derivative works, the cinematograph film or the sound recording, as the case may be. If their independent existence is recognized and retained intact, then how can you say that when the film is being communicated to the public, the underlying work is not separately being communicated to the public? Or how can you say that upon engagement by the producer, the owner of the author of the underlying work loses his or her rights in relation to that particular work? That is the argument that was raised in light of this language of Section 13.4. Now, coming back to this argument, Section 13.4, on which Mr. Ashok Sen, who was the lawyer for Council for IPRS, has leaned heavily in support of his contentions, lays down that the copyright in a film or a record shall not affect the separate copyright in any work in respect of which or a substantial part of which the film, or as the case may be, the record is made. So they're just highlighting what the provision says. Then they go on to say, though a conflict may at first sight seem to exist between 13.4 and 14.1a3. 14.1a3 dealt with the right of the owner of the underlying musical work and lyrics to allow the making of a cinematograph film and a sound recording, as the case may be. So he says maybe at first sight there seems to be a conflict between 13.4 and 14.1a3 on the one hand, and 14.1c2, which is the right, independent right of the owner of the cinematograph film to communicate that cinematograph film to the public as is, on the other. So on one hand, you have 13.4 read with 14.1a3, and the other hand, you have 14.1c2. And he said seemingly there was a conflict between these two. But then he goes to resolve that conflict by saying a close scrutiny and a harmonious and rational instead of mechanical construction of the said provisions cannot but lead to the irresistible conclusion that once the author of a lyric or a musical work parts with a portion of his copyright by authorizing a film producer to make a cinematograph film in respect of his work, and thereby to have his work incorporated or recorded on the soundtrack of a film, the latter, which is the producer, acquires by virtue of 14.1e of the Act on completion of the cinematograph film a copyright which gives him the exclusive right inter alia of performing the work in public, that is, to cause the film, insofar as it consists of visual images, to be seen in public, and insofar as it consists of the acoustic portion, including a lyric or a musical work, to be heard in public, without securing any further permission of the author composer of the lyric or a musical work for the performance of the work in public. In other words, a distinct copyright in the aforesaid circumstances comes to vest in the cinematograph film as a whole, which, in the words of the British Copyright Committee set up in 1951, relates both to copying the film and to its performance in public. Thus, if an author, composer of a lyric or musical work authorizes a cinematograph film producer to make a cinematograph film of his composition by recording it on the soundtrack of a film, he cannot complain of the infringement of his copyright if the author owner of the film causes the lyric or musical work recorded on the soundtrack of the film to be heard in public, and nothing contained in section 13.4 of the Act on which Mr. Ashok Sen has strongly relied can operate to affect the rights acquired by the author owner of the film by virtue of 14.1c of the Act. Now, they carve out an exception. The composer of a lyric or a musical work, however, retains the right of performing it in public for profit, otherwise than as part of a cinematograph film, and he cannot be restrained from doing so. In other words, the author, composer of lyric or musical work who has authorized a cinematograph film producer to make a cinematograph film of his work and has thereby permitted him to appropriate his work by incorporating or recording it on the soundtrack of a cinematograph film, cannot restrain the author owner of the film from causing the acoustic portion of the film to be performed or projected or screened in public for profit, or from making any record embodying the recording in any part of the soundtrack associated with the film. This is important because till now you seem to give the effect from the earlier part, from this part, that anything that is outside of the purview of the film itself can be controlled by the composer or the lyric writer. But the Supreme Court goes on to clarify that further, that as thereby permitted him to appropriate his work by incorporating or recording it in the soundtrack of the film. What cannot the author or composer do? They cannot restrain the owner of the film from causing the acoustic portion of the film to be performed, projected or screened in public for profit, or, and this becomes important, or from making any record embodying the recording in any part of the soundtrack associated with the film by utilizing such soundtrack, or from communicating or authorizing the communication of the film by radio diffusion, which is the earlier word for broadcast, as section 14.1c of the Act expressly permits the owner of copyright of the cinematograph film to do all these things. In such cases, the author owner of the film cannot be said to wrongfully appropriate anything which belongs to the composer of the lyric or musical work. Any other construction would not only render the express provisions of clauses F and Y of section 2, 13.1b and 14.1c of the Act OSHOs, but would also defeat the intention of the legislature, which, in view of the growing importance of the cinematograph film as a powerful media of expression and the highly complex technical and scientific process and heavy capital outlay involved in its production, has sought to recognize it as a separate entity and to treat a record embodying the recording in any part of the soundtrack associated with the film by utilizing the such soundtrack as something distinct from a record as ordinarily understood. So here is where the entire explanation is given as to why 13.4 is not relevant and why it is important to consider that because independent rights have been accorded under the Act in relation to a derivative work, which is the cinematograph film. Therefore, if you are to give separate significance and rights to the underlying work owner, even after they have permitted that to be part of the film, that would effectively defeat the rights of the cinematograph film owner, who would then, or whose licensee would then nevertheless have to go back to the owner of, or the author in this case, but the owner of the underlying works, to seek permission once again from them for every subsequent exploitation, as long as it is not part of the film. And when you see the language in provisos to 18, 1909 and 1910, actually specifically third proviso to 18 and 1909, and then 17, the new proviso, you see that what they were trying to achieve by amending was to undo the alleged mischief of this particular case, which they thought was the mischief, saying that fine, we can understand that when a cinematograph film owner, producer creates a film, their primary platform for exploitation is a cinema theater. I mean, to my mind, very frankly, this is a very old sort of thought process, because today there are so many multiple platforms for exploitation available, and you may or may not get the maximum from theatrical. Maybe today, even today, theatrical gives you maximum, but that may change in the future. And the law does not have to be backward looking. The law has to be forward looking and has to be agnostic to the platforms that are either there or are likely to come in future. So from that point of view, the seeming intent of the amendments as set out in third proviso to 18, 19.9 and this 17 new provisos seem to be to suggest that Supreme Court actually meant to limit the right of the producer only to the communication to the public of the film and only to cinema theaters and nothing more. So anything that you do beyond that in terms of exploitation of music, you need to separately pay for. To my mind, that's an incorrect interpretation. Of course, it's before court and we will see how it plays out, but that's what it is. And now let's just go to the ratio of the case. Sapna, I'm stopping to share my screen. Why don't you go back to present?
Abhishek, I suggest this is a better copy. Why don't you scroll down to para 17? That's where the relevant part of the judgment
Okay,
is.
see, all right. Okay.
Yeah.
Huh. On a conspectus of the seat. No, this takes us to the court.
This takes us to the court. Yeah, that's where it starts.
Yeah, this is where it starts.
Yeah.
Unfortunately, this is not numbered, but nevertheless, I'm just making it slightly bigger so that it's easier to read. Yeah. This takes us to the core of the question, namely, and I put up the question right up earlier, and if you want to see it again, I'll just quickly take you back to that question before we come back to 17, so that the question that is being answered in para 17 is the same one that is raised. Whether in view of the provisions of the Copyright Act, an existing and future rights of music composer, lyricist, is capable of assignment. So this is the first part. And whether the producer of a film can defeat the same by engaging the same person, which is the composer or the lyricist. So one, whether it is capable of assignment, and this is very important when we come to the new proviso of 17, and whether the producer can defeat by engagement. And now the Supreme Court goes to answer this question in 17, and let's see how it answers it. Because that the manner in which it answers it and the provisions on which it relies upon to answer that question become important to us. This takes us to the core of the question, namely, whether the producer of a film can defeat the right of the composer of music or lyricist by engaging. The key to the solution of this question lies in provisos B and C to section 17 of the Act, reproduced above, which put the matter beyond doubt. I'm pausing here for a moment. The proviso B and proviso C have not been amended. So the interpretation of the Supreme Court given to these provisos in 1977, to my mind, still holds. It still holds good. Other important part is section 14 is not amended. Section 13 is not amended. And section 17 provisos B and C are not amended. So just keep these in mind when we come to the discussion that we are heading towards in terms of interpretation of what, if at all, are the changes that have been brought about by virtue of the amendments in 2012. Sorry. So the key to the solution, one second, please. Key to the solution of this question lies in provisos B and C to section 17 of the Act, reproduced above, which put the matter beyond doubt. According to first of these provisos, that is proviso B, when a cinematograph film producer commissions, now you will not find this word commissions in the proviso itself, but it comes out in this judgment. So the Supreme Court is interpreting proviso B to mean that proviso B deals with commissioning of a work. And it categorically says that when a cinematograph film producer commissions a composer of music or a lyricist for reward or valuable consideration for the purpose of making his cinematograph film, or composing music or lyric therefore, that is the sounds for incorporation or absorption in the soundtrack associated with the film, so again very categorical, which as already indicated are included in a film, he as in the producer, becomes the first owner of copyright therein. Therein is not the film, therein is the underlying work. And no copyright subsists in the composer of the lyric or music so composed, unless, yes, there is an exception, unless there is a contract to the contrary between the composer of the lyric or music on the one hand and the producer of the film on the other. So the default proposition under proviso B is A, it operates as a commission. B, that the producer of a film commissions the music composer or the lyricist, as the case may be, by virtue of engagement under proviso B, which is a contract for services. It is not a employer-employee relationship. It's an arm's length relationship. It's a contract for services. And it is a specific commissioning of the work by the producer of the underlying author of the composition of music or lyrics. And in such instances, it is he, the producer, who becomes the first owner of copyright therein, as in the underlying works. And the reason why I'm saying therein means underlying works is because it follows to say, and no copyright subsists in the composer of lyric or music so composed unless there's a contract to the contrary between the composer of lyrics and the music.
Okay, Abhishek, before you continue reading that, just 1 second. Yesterday, while we were discussing and going through the PPT, after section 18, there was a food for thought, where we actually raised this as a question that when a producer is commissioning the work, does the producer in that sense step into the shoes of the authors? And is it the same entity or are these different entities? So just to tie the link, the answer has been provided in the 1977 judgment, where the Supreme Court has specifically said what Abhishek just read out, with special emphasis saying that no copyright subsists in the composer of the lyrics or music so composed. Of course, the exception being there unless there's a contract to the contrary.
So the same result, now the court goes on to say, okay, this is the outcome of proviso B, then looks at proviso C. The same result follows according to aforesaid proviso C if the composer of music or lyric is employed under a contract of service or apprenticeship to compose the work. That's fairly clear, just a restatement of that. It is therefore crystal clear that the rights of a music composer or lyricist can be defeated by the producer of a cinematograph film in the manner laid down in provisos B and C of section 17 of the Act. So it has answered the second part of the question that it raised earlier. Can the producer defeat the rights of the underlying creators of the works? Yes, it can defeat those rights pursuant to an interpretation that Supreme Court has afforded of provisos B and C to section 17. Axiomatically, even though it does not say so, but axiomatically, therefore, if the producer is commissioning a composer or a lyricist, or as the case may be, a story writer, dialogue writer, someone who's creating, let's say, the sets in terms of an artistic work, anyone who could possibly be construed as a creator stroke author for the purposes of the works identified under 13(1)(a) of the Copyright Act. In such cases, if upon creation of that work is not created when the engagement takes place. That work gets created after the engagement, after the commissioning takes place. So the work gets created consequent upon and further to and after the engagement. And therefore, immediately upon creation, it vests in terms of ownership in the producer itself. If that be the case, there is nothing left in the author-composer to assign to anybody, including but not limited to the producer. And if that be the case, then the first part of the question, whether it is capable of being assigned, gets answered accordingly. So both the questions get answered. Are these capable of being assigned? No. The only way that they can be capable of being assigned is if there is a contract to the contrary between the composer of lyrical music on one hand and producer of the film on the other. Only one situation. Or if there is a pre-existing work which is brought to the producer by the author, who by that time also has become the owner, because the default position under section 17 is that unless subject to the provisions of the Act, the author is the first owner of copyright in relation to a work. So if someone comes with a story stroke screenplay stroke anything to the producer, and or musical work already created, musical composition already created, lyrics already created, in that case the work already subsists. There's no question of commissioning. And there's no question then of employment. Unless, of course, I'm sorry, I'm making some further exception, unless there is an ongoing employment between the producer and then that person creates it. That's a huge exception, but that's the only exception. Otherwise, in all other circumstances, producer is the first owner of copyright, and therefore there's no question of an assignment situation coming into play. And then it says, for the foregoing reasons, we do not find any justification to interfere with the order of the High Court. Consequently, appeal fails and is dismissed, but in the circumstance of the case, without any order as to costs. Now, what IPRS has continuously tried to stick onto or latch onto in terms of this decision is that yes, it was a two-judge bench of the Supreme Court. Yes, there is really no dissenting view of Justice Krishna Iyer. And he himself says that the judgment just delivered is on behalf of the court. So he's not dissenting, which makes this footnote, so he's referred to his note as his addition as a footnote. And he says it is in a sense ocious, it's irrelevant. But I do append the abbreviated opinion solely to belight a slightly penumbral area of the law. This is typically Justice Krishna Iyer in his mellifluous language, which basically he's saying that and to voice a need for legislative exploration to protect a category now left in the cold. So he's saying, I want to say something only because I think that there is a penumbral area of the law, that which you cannot see. And he wants to voice a need for legislative exploration, a need for amendment to protect a category now left in the cold. Here, as people who want to read subsequently will note that this category that he's referring to is performers. And he just says that, look, there's no protection for performers, there should be. But IPRS has latched on to this for the reason that Justice Krishna Iyer, while expounding this portion, makes certain statements which seem to suggest that IPRS and or the owner of copyright or the authors or representative authors should be paid something independently if and when the music or the sound recording is exploited independent of the film itself. So and it says, I'll just quickly take you through that before we go back to Sapna and the subsequent decisions that she's going to discuss. So he starts with this, he starts with the emphasis on how cinema needs protection because it is not just merely a coming together of people who want to contribute financially. But a cinematograph film is a felicitous blend, a beautiful totality, a constellation of stars, if I may use these lovely imageries to drive home my point, slurring over the rule against mixed metaphor. Cinema is more than long strips of celluloid, more than miracles of photography, more than song, dance, and dialogue indeed, more than dramatic story, exciting plot, gripping situations, and marvelous acting. But it is that ensemble, which is the finished product of orchestrated performance by each of the several participants, although the components may sometimes in themselves be elegant entities. Copyright in a cinema film exists in law, but Section 13(4) of the Act preserves the separate survival in its individuality of a copyright enjoyed by any work, notwithstanding its confluence in the film. This persistence of the aesthetic personality of an intellectual property cannot cut down the copyright of the film qua film, which means that when you are looking at a film as is, you will not look to the individual elements to steal a march over the producer of the film. The film being exploited in any manner should not require the independent exploitation of the underlying works. That's already there. The latter right is, as explained earlier in my learned brother's judgment, set out indubitably in section 14(1)(c). True, the exclusive right, otherwise called copyright in the case of a musical work, extends to all the sub-rights spelled out in 14(1)(a). A harmonious construction of section 14, which is the integral yoga of copyrights in creative works, takes us to the soul of the subject. The artist enjoys his copyright in the musical work. The film producer is the master of his combination of artistic pieces, and the two can happily coexist and need not conflict. What is the modus vivendi? The solution is simple. The film producer has the sole right to exercise what is his entitlement under 14(1)(c) qua film, but he cannot trench on the composer's copyright, which he does only if the music is performed or produced or reproduced separately in violation of section 14(1)(a). For instance, and this is where IPRs or other people latch on. For instance, a film may be caused to be exhibited as a film, but the pieces of music cannot be picked out of the soundtrack and played in a cinema or other theater. He also goes to the extent of saying that in a cinema theater, when there's a break and you only hear a soundtrack or the sound recording, you can't even do that. To do that is the privilege of the composer, and that right of his is not crowned in the film copyright except where there's a special provision, such as in section 17 proviso C. So he goes on to say that proviso B perhaps is not the correct interpretation to come to this conclusion. Only when you engage someone under a contract of service as an employee can you really say that you have acquired everything. So beyond exhibiting the film as a cinema show, if the producer plays the songs separately to attract an audience or for other reason, he infringes the composer's copyright. Anywhere in a restaurant or aeroplane or radio station or cinema theater, if a music is played, there comes into play the copyright of the composer or the performing arts society. These are the boundaries of composite creations of art, which are at once individual and collective, viewed from different angles. And then he goes into Mona Lisa and other stuff. Important part is that seemingly there is a conflict between this part of the judgment and the judgment penned by Justice Jaswant Singh. The reason why subsequently the courts have continued to hold that Justice Krishna Iyer's judgment is obiter at best and at worst only a footnote or oshos is because of the fact that the manner in which the judgment is written, he himself seems to suggest that this is only his own view that may be personal to him, and while he's saying what he's saying, he agrees with the judgment of his brother judge. The judgment just delivered is on behalf of the court. He himself says that, which makes this footnote in a sense oshos. And because he says the only reason why he's appending the abbreviated opinion, it is solely to belight a slightly penumbral area of the law and to voice a need for legislative exploration to protect a category now left in the cold, which subsequently he deals with in terms of a performer. And where he says a somewhat un-Indian feature we notice in the Indian Copyright Act falls to be mentioned. Of course, when our law is intellectual borrowing from British reports, as admittedly it is, such exoticism is possible, musical works such and such. Therefore, copyright music is not the soulful tune, the superb singing, the glorious voice, or the wonderful rendering. It is the melody or harmony reproduced to print, writing, or graphic form. Indian music lovers throng to listen to or be enthralled or enchanted by the Nada Brahma, the sweet concord, etc., etc., etc. Strangely enough, author as defined under 2D in relation to a musical work is only the composer, and section 16 confines copyright to those works that are recognized by the Act. This means the composer alone has a copyright on musical work. Now, the singer has none. This disentitlement of musician or group of musical artists to copyright is un-Indian because the major attraction which lends monetary value to musical performance is not the music maker so much as the musician. Perhaps both deserve to be recognized by copyright law. I make this observation only because Act in one sense depends on the ethos and aesthetic best of a people. And while universal protection of intellectual and aesthetic property of creators of works is an international obligation, each country in its law must protect such rights wherever originality is contributed. So viewed, apart from the music composer, singer must be conferred a right. Of course, lawmaking is a province of parliament, but discourse must communicate to the lawmaker such infirmities as exist in the law extant. So if you actually see, the reason why he wanted to put this opinion is for this particular paragraph, to observe that there should be some rights for singers stroke performance, nothing more, which is why courts have said that because Justice Krishna Iyer himself said that the judgment is delivered on behalf of the court, that's why what will be read is Justice Jaswant Singh's judgment and not this part. Sorry, just handing over to Sapna. Sapna, you can share your screen now, please.
Yeah. Okay, so we read thoroughly into the 1977 judgment. We also looked into this, so I'm skipping the slide. I'm going to the next one. So it's not a case that there have been no judgment revolving around this issue post 1977. In fact, this judgment of 1977 has been relied by courts in various other judgments, including the Bombay High Court and the Delhi High Court. And the most notable cases in these are the ones which are mentioned on these slides. But what I'll do is I will take you guys through, not at length as Abhishek did, but of course I'll try and bring out what the issue was with regards to Aditya Pandey judgment. So this was a challenge which went before the Delhi High Court, before the single judge. And from there, it went to the division bench and then to the Supreme Court. The third citation mentioned in the Supreme Court citation, but Aditya Pandey judgment, primarily what had happened is this was a case which IPRS had filed a suit seeking injunction against an event management company, alleging copyright infringement. Now, the issue that IPRS raised was that the lyrics and music were used to make sound recording by a sound recording company, which is exactly what is the concern or the debate and the discussion that we are having since yesterday, that the literary and musical work is used to make the sound recording. So the question that was asked was whether the event management company was required to take a license from the lyricist and the musician for playing the song in the public, for which the event management company had already procured a license from the sound recording company. So technically the issue was the same, that today when the event management company has procured a license from the sound recording company, does it still require to take a license for the underlying works?
Sorry, Sapna, you're referring to the IPRS's Aditya Pandey matter?
Yes, Aditya Pandey.
No, so there were, I'm sorry, because I was involved in that matter, there was just, there were two aspects to that matter.
Okay.
Two suits got clubbed. One was in relation to an event management entity which was organizing events, and the question that was put in relation to that part of the case was that when an event management company is organizing an event, does it necessarily have to take permission both from IPRS as well as from PPL? PPL is the entity that manages the sound recordings. The question, however, in the Aditya Pandey case, which related to a radio broadcaster, was simply that radio broadcasters broadcasting sound recordings. Do they need, and they have taken a license for the sound recording or are in the process of doing so, whatever. And do they, in that event, need to take a separate license for the underlying work when they're broadcasting the sound recording? So that is the issue. Sorry.
Just to read out what was the question framed by the court in that case. Actually, it's in para 34 right then that the question gets framed, because till then the court have actually discussed as to what the law in India has been going into details of what section 13, 14, the definition of works, communication to public, and have also to a great extent dealt with what the law in UK has been. And just going back to the question that was framed by the court, it says that from the above discussion, it is evident that two questions arise for consideration in this case. The first one being the extent of the songwriter's copyright and whether it extends to excluding the communication to public with authorization of the musical work embodied in a sound recording. And the second one being, does hiring of a place hired by an employer and it's used by the event manager for the purpose of communication of musical work or sound recording, amounts to public performance within the meaning of the act. Now, taking you guys to what the court held. I will just... So the court said that it deemed appropriate to adopt an interpretation consistent with the one indicated in the Eastern IMPA judgment. This is the same 1977 judgment that we just looked into. And in this paragraph, the court said, I'll read it out. If one notes that sound recording copyrights post 1994 have been carved out of the pre-existing copyright. Hello? Sorry, I'm reading another paragraph. Abhishek, do you want me to deep dive into the reasoning or come to the conclusion directly?
No, I think the reasoning is pretty much consistent with the 77 judgment.
Yeah.
I would want you to come to the conclusion only, and just where the court says it talks about the fact that if the court were to conclude in a different manner, in as much as they were to conclude that the underlying works also get exploited simultaneously when the sound recording gets exploited, then they would be rendering a judgment which is at variance with 77, because by then what they will be doing is putting both the derivative works of a sound recording and a cinematograph film on different pedestals, and therefore discriminating between the two, even though they are both derivative works. So just that part, I think if you can highlight from judgment and the conclusion.
Okay, sure. So, so in para 49, it was basically held that once a license is obtained from the owner or someone authorized to give it, in respect of a sound recording for communicating it to the public, including by broadcasting, a separate authorization or license is not necessary from the copyright owner or author of the musical or literary work. So in essence, this is what the court, the single judge held in Aditya Pandey, that if you are procuring a license, then a separate authorization for using or communicating the underlying works is not required to be procured. So the court then drew a distinction with regards to the performances, and carving that out and not bringing the performance aspect within the judgment. The exception that they made was when the performance is happening, that would separate and to be treated as separately and cannot be bundled with these rights. What happened was Aditya Pandey judgment was obviously taken in appeal before the division bench and then right up to the Supreme Court. And both the division bench and the Supreme Court have upheld the view taken by the single judge. So that pretty much answers the question that we've been discussing, that whether a separate license in that sense is required to be taken when there is an exploitation of underlying works that is being exploited. Abhishek, would you like to add something?
No, I don't. I see, the only thing that I wanted to point out is when it went up to the, so two things I want to point out.
Yeah.
It was categorically argued before the division bench, vehemently so, that Justice Krishna Iyer's judgment needs to be looked at, with greater amount of deference, because of the fact that it has come from Justice Krishna Iyer and because it is the Supreme Court, etc. The DB, single judge and DB both concluded that regardless of the fact that it has come from another judge of a two-judge bench, clearly the judgment has not been reported as a split verdict. And if it was a split verdict, it would have been referred to a larger bench. So clearly it's the decision of the court, and therefore we are going to refer to that part which seems to be the leading judgment, which is that of Jaswant Singh. That is one part of the judgment. The second part of this series of judgments is that by the time the Supreme Court decided this case in appeal in 2016, it was already, the amendments had come into effect. The single judge decided in July 2011. The division bench decided in May 2012. Amendments came about in June 2012. And the decision of the Supreme Court came in September 2016.
September 16.
So by that time, the amendments were already there. So part of the argument that was raised by IPRS was that while this suit relates to a pre-amendment situation, and assuming without conceding that pre-amendment, the scenario was that nothing really, there was no rights available in the underlying works, either to the author or their society. But today the position of law has changed, and clearly by virtue of Proviso 3 to 18 and Proviso 4 to 18 and 1990 and 1910, there is a right that is available to be separately exploited and paid for. The Supreme Court says two things there. And again, there is it's a two-judge bench. Seemingly, there is a decision that is given by Justice Prafulla Pant. And there is an opinion, like in the case of Justice Krishna Iyer, though it does not say that this is frivolous or ocious, but there's an opinion given by Justice Gogoi. And he seems to undo the effect of whatever Justice Pant has said. And just if you can give me a moment, I'll pull up that judgment so that I can show you how it has only furthered the confusion instead of clearing it. Just 1 second. Sorry, I'm just opening that judgment. So as you can see, this is the judgment that was rendered by the court. The main judgment came from Justice Pant. There are a couple of interesting things that the court concludes in this judgment. The first one being that till the coming into effect of the amendments of 2012, they came into effect on 21st June 2012. And it considers the 77 judgment, it considers other judgments, etc., and comes to the conclusion. Just give me a second. Yes. A conjoint reading of various provisions of the Act leaves no doubt that though each of the 7 subclauses of Clause A of 14 relating to literary, dramatic, or musical work are independent of one another, but reading these subclauses independently cannot be interpreted to mean that the right of the producer of sound recording, who also comes under the definition of author under 2D5 and has a right to communicate his work to the public under 14E3 of the Act, is lost. It is nobody's case that the defendant respondents had stolen the lyrics or that sound recording is made without license from the lyricist or musician. Argument advanced on behalf of appellants that the permission granted to the defendant was sans the right to communicate the sound recording to the public cannot be accepted as there appears no such term and condition between the parties depriving the defendant from communicating his work of making the song to the public. As far as international conventions and treaties are concerned, the law has been amended by Act so and so. In the present case, the suit was filed in 2006, and the law as it existed has to be applied for the period prior to 21/6/2012. We agree with the division bench of the High Court that the song is created by three players, namely lyricist, musician, and singer. We have to examine the present case as to what extent, if any, identities of the above three players break or get diluted when a song is created and sound recording is done. To understand this, the relevant provision of law quoted above, we would like to remind of such and such, the observation under this particular judgment. And then IPRS versus Eastern India Motion Pictures, paragraph 15, which I read to you guys earlier, and say that in view of the above settled principles of law and for reasons discussed by us, we are unable to find any error in the impugned order passed by the High Court in the suit filed in 2006. Now, so therefore it holds that when you are playing a sound recording and you have a license to play that sound recording, you need not take a license in relation to the underlying works. But however, we would like to clarify that with effect from 21/6/2012, in view of subsection 10 of section 19 of the assignment of copyright in the work to make the sound recording, which does not form part of a film, shall not affect the right of the author of the work to claim an equal share of royalties and or consideration payable for utilization of such work in any form by the plaintiff respondent. Right? So it categorically says that the law as it existed till 21/6/2012 was that you do not need to pay once you take a license for the sound recording. But post 21/6/2012, seemingly the law has changed, and it's a matter of, to my mind, it's a matter of conjecture and not finality, whether this part of the judgment is a ratio of the judgment or it is only an obiter, it's only a reference. For whatever it is worth, there is a mention which says that subsection 10 of section 19 allows for the underlying author to continue to get royalty. Now, very interestingly, and I'll come back to this when we are looking at 18 and 19 again, Supreme Court also, while saying that the position of law has changed after 21/6/2012, makes a reference only to subsection 10 of section 19, which is sound recordings that do not form part of a film, independent albums. 19.9 talks about those sound recordings which exist part of the film, which is consistent with what we've been saying all this while. The producer of the film owns everything. But as one of the questions that I was answering separately on the chat raised a question that maybe in the event that there is a situation where it's an independent album being produced, 17 Proviso B contains the word cinematograph film, but does not contain the word sound recording. In which case, when an independent sound recording is being made, which is not part of a film, there cannot be a situation where there is a commissioning of the work. Then the only way the sound recording company can own that copyright of the underlying work is either if they have employed the author composer under 17 Proviso B, C, or that there is an assignment. So in the case of an assignment, 1910 comes into play, in which case where you are exploiting a sound recording which is not part of a film, you may still need to pay separate royalty to the author composer. So it's an interesting quirk that Justice Prafullapan brought out. Whether or not this is the final law, this will be discussed in the judgment that there are cases that are still pending and are under consideration. One further aspect of this, there's another part of the judgment which is given by Justice Gogoi. And he says, I have had the privilege of going through the judgment prepared by my learned brother. While agreeing with the conclusions reached, I would like to very briefly indicate the reasons for the same, which are somewhat different. So he agrees with the conclusion that they're upholding the judgments of the single judge and division bench to say that if you have a license in relation to the underlying work, to the sound recording, you do not need a separate license in relation to the underlying work. But he says my reasons are slightly different. And then he goes into a consideration of the division bench decision and the single judge. But he says that why are we going into so much of details at this interim stage? We should try to find finality to these judgments after the trial is conducted. Now, the problem is his last paragraph. Having said what was felt required and necessary, only 6 paragraphs, we dispose of all the appeals by holding all observations, findings, and views expressed by the High Court in the original as well as the appellate proceedings before it to be of no legal effect whatsoever, insofar as the merits of the suits are concerned, which will now be expedited and heard and disposed of within a year from today. So all the supposed hard work of Justice Pant has been undone by this one line, or is it? One doesn't know. This is being argued. Both sides are relying on different aspects of this judgment in the ongoing proceedings before the High Court, and we'll see what outcome of comes of it. But as I said, these are judgments. We come back to advancing our own interpretation as per what we set out. Over to you, Sapna.
Okay. So, having looked at the judgments, the second ground of defense that we briefly discussed at the beginning of this session was the provisions. So, going back to what we were looking, one second, I'll just share the PPT. The 3 grounds that we mentioned, we've looked into all the judgments that have been passed by the court and the interpretation that the judgment, the way it's said, and the possible interpretation that is being sought to be taken today. There is one thing, as Abhishek has already mentioned, though these judgments dealt with provisions which were prior to 2012 amendment, it is important that all these sections which have been discussed in these judgments have not been changed. So the amendment has not modified these provisions, and thus it is an arguable thing that the position of law in that sense has not changed, and the judgments, the way they've been pronounced, stand good. That brings me to the second defense that we were talking about, is that musical and literary works are separate and distinct from sound recording. Now, just to elaborate this a little further, as we were discussing this from a radio station's perspective, so technically, what is it that a radio station is doing? It is communicating the sound recording on its platform. It's not indulging in any form of live performance of the literary or musical work. So then, by that logic, going by the Aditya Pandey's judgment, if a sound recording company has procured a license from the copyright owner of sound recording, that should be sufficient. And if that is the case, then IPRS does not have any basis to ask a radio station to come and procure a license or pay royalties with regards to that. To take this thought process further, so the radio station is only exploiting the sound recording, which is an independent copyrighted work and is different from the underlying works. That is to say that the literary and the musical work which get incorporated, or the term that we use is subsumed into sound recording. When a sound recording is created, these are 2 separate rights. And as we've seen from the definition of work, section 13 and section 14, these are also being treated separately by law itself as separate classes having separate rights. actually we've dealt with this earlier, but once again want to reiterate that section 14E specifically sets out the rights that are there with the owners of the sound recording, and which rights are to make any sound recording, to sell or to give on commercial, rental, or to communicate the sound recording to the public. So these rights are distinct and separate from the rights that are available with a lyrical and musical work owner. So what we are trying to drive this argument today is to say that once literary and musical work gets incorporated in a sound recording, no right in the same is claimed as a part of the sound recording. Okay, let's just go back to IPRS's interpretation and let's test that. So today, if we have to practically test that, are we saying that there is a conflict between section 13.1a and section 13.1c? So 13.1a, as we saw yesterday, sets out the classes in which copyright subsists, in which A deals with dramatic, literary, and musical work, and 13.1c deals with sound recording. So are we saying that there is a conflict between these two provisions the way it is? And the result of such interpretation is the right of the owner of the sound recording, of communicating the sound recording to the public, is not a full and absolute right, and that it stands curtailed by the right of the owner of the underlying works. If that argument is to be tested, we will have to go back to the 1977 judgment, where it categorically said that that is not what the case is. So thus, to our mind, what we're saying over here, which has been briefly put out on this slide, is that sound recording is a separate right, is a different class altogether. And therefore, if one has the permission from the copyright owner of sound recording, there is no need to procure a separate license from IPRS and or pay royalties for that matter. And just to further emphasize that what I just read out from a sentence from section 14E, which deals with the rights of the owner of sound recording, it also has the right to communicate the sound recording to the public. So in that sense, it's a composite right, and you don't really need to go to an IPRS to procure a license even for communicating the sound recording to the public. This brings me to the last defense that we were talking about, is
Sapna,
what was the, yeah?
We can't see the PPT, I think. We can still see the IPRS judgment on the screen.
No, actually, let me stop sharing and share again. Can you guys see it now?
Yes, Sapna.
I know.
Oh, okay. So that brings us to what was the legislative intent at the time when the 2012 amendments were being discussed, and whether the legislature actually wanted to dilute the rights of the owners of the sound recording. Because we specifically saw that the owners of the sound recording have the right to communicate to the public, including the various other rights that they have. So in this connection, what I've done is I have copy pasted 2 paragraphs from the parliamentary committee report, which was a parliamentary standing committee report number 227. And there has been a lot of discussion that happened pre-amendment. And the discussion which took place was on the words other than part of sound recording. And at that point of time, a viewpoint was pressed that these should be deleted to enable the owners of underlying works to claim royalty. I would like to emphasize that the discussion precisely was happening on the point whether these words should be deleted to give effect that the owners of underlying works should be entitled to claim royalty. And if one looks at these provisions or these discussions which have been extensively dealt with in these para 10.9, 10.11, and also a couple of more paragraphs at certain length in 10.11 and 19 of the Parliamentary Committee report, it shows that the royalty becomes payable when the underlying works are being exploited through different modes other than the part of sound recording. So at the stage of discussion, it was categorically ruled out that there is no need to include royalty aspect or attach a royalty component to be paid to the underlying works owner when there is an exploitation of sound recording that is being taking place. So I'm not sure, Abhishek, do you want me to read out these paragraphs or the summary will suffice?
No, I don't need to read out the paragraph.
Okay. So just to conclude, if one looks at these three stands that we've taken, it is a good defense to our mind, and for the judges now to evaluate whether it is correct to say that today sound recording is a separate component altogether, a separate class in itself. And that's why today, if a permission is there from the owner of sound recording, one really does not need to go back to IPRS and procure a second license from IPRS, whether it's for communicating the work to the public or whether it is the exploitation or utilization of the underlying works, as is what IPRS is claiming today. Okay. So if we go ahead and now evaluate the position or the case that a producer of a show or a film could probably have, what I've done in this done here is just posed questions, because we have practically discussed a lot of scenarios already in our discussions from the point of view of the judgments that have been passed in the past, or from the point of view of what the act says and how it can possibly be read into. So from a producer's point of view, a producer's contention or a defense possibly will be that the producer is the first owner of copyright, that is under section 17 that we discussed. And thus a producer can say that for subsuming the lyrical and musical work into sound recording, it's again one of the argument possible. I don't know whether this argument has actually been taken or not, but can this also be interpreted to say that, okay, even if a fast-fetched imagination, I have to say that royalty is payable to the authors of literary and musical work, it is a one-time use that I am doing when I am subsuming this into a sound recording. So is it that it's a one-time activity and that a royalty is required to be paid only once when that work is actually being paid, subsumed into sound recording? And then going forward, since sound recording is a separate category governed by separate rights, there is no royalty required to be paid to the authors of the musical and lyrical work, which if the question is posed to me, a conjoint reading of all these sections could be one of the possible interpretations that a court could take. The other question that we had was that an author who has not assigned the rights to IPRS, so can he directly be paid by the owner of copyright? Now, to give an example for this, so if we take a producer of a show and if he engages a a lyrics writer. Now, if the lyrics writer is not a member of IPRS, he is still entitled to receive royalty. And if he's still entitled to receive royalty, then is it okay for a producer to directly pay the royalty to the author who is not a member of IPRS? To my mind, I don't see it as a problem, because when we looked at section 13, which dealt with assignment, it said that a owner of copyright may assign. So the word used is may. It's not an obligation that there has to mandatorily be an assignment. So if I have the rights and I am entitled to receive royalties, given a reading of section 33, then I would say the author can receive these royalties from the producer of the film. Now, a very interesting point, which I think we can discuss today, is what happens, suppose if an author today has assigned its rights to IPRS. So if anyone has had a chance to look at IPRS's agreement, the assignment is not only for its present works, it's also for its future works. So assuming today an author has assigned its rights to IPRS, can the author really withdraw his authorization and say, you can monitor my present rights, but whatever I create in future, you do not have the right to monitor that? Is that something that can be done? The reason I'm raising this is tomorrow, if suppose I am engaging an author who is already a member of IPRS and has already assigned its future works to IPRS, then there may be a conflict that we are looking at from a perspective of first right of owner and an assignment which has already taken place before the commissioning of the work comes into picture. So it possibly would be an advisable thing to start thinking on the lines that if a person or an author who is already a member of IPRS, I should technically, then he should withdraw his authorization from IPRS with regards to his future works. Is that one of the options for the industry to work smoothly? Honestly, at this juncture, I don't have an answer to this. And if Abhishek can throw some light, if he has some thought process on this.
Sapna,
Yeah,
hello.
Prashant.
Yeah,
Yeah,
this is
Prashant.
on the website of IPRS. I think there are two columns. One is the old assignment and new assignment.
Yes.
Okay, so I believe there are cases where people are amending their original assignments and making modifications and reducing the mandates or adding to it. So I think this is already being done. Where
Okay.
yeah, go ahead.
Prashant, yeah. So Prashant, to the best of my understanding, what has happened is
Hmm.
there were assignments given by the members earlier,
Okay,
and post IPRS re-registering itself, there were certain assignments which were for a limited period of time.
okay.
And when those reassignments were happening, is when those new assignment agreements are being shown.
Okay, so it was not to vary the terms. It was just for the term of length of the assignment.
Yes.
Okay.
Abhishek?
Yeah, I'm very much here.
Yeah.
No. So there are a lot of different ways in which that particular provision can be, or provisions can be interpreted. My thought process on that interpretation is as follows. Clearly, section 13, 4, 14, 17 proviso B and C have not been amended. That being the case, the entitlement of first ownership flows to the producer of the film from provisos B and C and the interpretation accorded to those by the Supreme Court of India. Now the only point is, as is being argued by IPRS, can the insertion of the new proviso to 17 read with the third and fourth provisos to 18 and 19.9 and 19.10 give to IPRS and or its members the right to claim copyright in relation to the underlying works in opposition to and in dispute with the producer of the film. So for that, Sapna, if you can stop sharing your screen, I will take people to the new proviso to 17.
Sure.
Can everyone see this now?
Yes.
Yeah.
Yes.
Okay, so this proviso says in case of a work, of any work, now we are incorporated in a cinematograph work. So any work incorporated in a cinematograph work would be an underlying literary work, a musical work, or maybe an artistic work. Nothing contained in clauses B and C, perhaps it is a reference to provisos B and C, shall affect the right of the author in the work referred to in clause A of subsection 1 to section 3. Now, section 13(1)(a) talks about the original literary, dramatic, musical, and artistic works. And this is the work referred to in such and such, in this particular clause. So let's take the case of a literary work or dramatic or my musical work. The provisos B and C, supposedly, as per this additional proviso, shall not affect the right of the author in the work referred to in clause in 13(1)(a). Question is, and it's a fundamental question, where is the right of the author? Because 17 talks about
Ownership.
a default position that the author is the first owner of copyright. So the rights that are accorded are to the owner of copyright. The only right that is given to the author as such is under section 57 in relation to moral rights. So there is really no right of the author of the work mentioned in 13(1)(a), because 13(1)(a) does not talk about any rights. Rights are in 14 and rights are then in 57. Now, in terms of the effect of this provision, to my mind, the effect of this provision is no different from 13(4), which also recognizes the separate existence of a work under 13(1)(a). This recognizes that existence of a separate work under 13(1)(a), but goes a little further to talk about the right of the author. Anji.
Hello.
Yeah.
Abhishek, can I add one thing?
Please.
Does this right which is being referred in this proviso refer to the right of receiving royalties? That's a commercial right. which is which was sought to be amended and added in 18 and 19.
Let's look at that. Now, what does 18 and 19 say?
So maybe they don't want that the right of the authors get defeated as regards the right to receive the commercial benefit of the exploitation of their work apart from the purpose for which they were assigned. For example, yeah.
I agree with you that that's one of the interpretations.
Hmm.
The question, I mean, of course, very simplistically, if that is what was sought to be achieved, to my mind, one aspect is that this right to receive royalties, right?
Yeah.
Should have been incorporated in 14
Correct.
as a right, an exclusive right.
Yeah.
Right?
Yeah.
That's one. Second thing is, once you place this under 18 and 19, then the question is that because it relates to a situation where there could be either an assignment or a license, what happens as per the interpretation accorded by the Supreme Court that there is no question of an assignment being given? You remember that I highlighted the question that was raised by the Supreme Court in 77. There were two parts to the question. Whether there's a requirement of an assignment and whether the right can be defeated by the producer.
Yes.
Right?
Yes.
If, as per a matter of law, the producer can defeat the rights of the author composers by the engagement under B or C, then there's no question of assignment because nothing remains to be assigned.
Correct.
And then you do not need to even go to 18 and 19 because 18 and 19 contemplates a situation where there has been an assignment.
Yes.
Therefore, consequently, the right to receive royalty.
Correct.
That's my argument, and I'm not saying that this is like something which would be necessarily upheld in law by court. It has to be argued that what is the whole purpose of putting such a provision in when you're not even granting such a right. But my counter argument is that it's not as if the law does not contemplate a situation at all where such a right of receiving royalty cannot be exercised. It can be exercised. It can be exercised very clearly in the fourth proviso, as has been indicated by the Supreme Court in that 2016 judgment by using 1910, because 1910 ties in with the fourth proviso to 18.
Yes, yes.
Right? So that's my argument that